children. This is Srikanth signing in for Contracts 1. Yesterday we are seeing about privity of the contract. That means a stranger to a contract or privity of a contract. The general rule, what is the general rule? Only parties to a contract alone can sue and be sued on that contract, and any person other than the parties to the contract is a stranger to the contract. A contract neither confers any right nor imposes any duties obligations on such person. Hence, a stranger to a contract cannot sue and be sued. So this rule is known as doctrine of privity of contract. So for example, A is there, B is there. They both enter into a contract. If any person breaches the contract, only either A or B alone can go to the court and file a suit for their enforcement of their rights, and third person cannot file a suit against either A or B. Why? Stranger to a contract cannot sue. So, however, there are certain exceptions to this rule. So, even though a person is a stranger, he can file a suit against third persons. Even though a person who is not a party to the contract, he can sue the persons. It is known as privity of contract. So there are certain exceptions to this general rule that a stranger to a contract cannot sue. நார்மலி என்ன நடக்கும்னா கான்ட்ராக்டில் டூ பார்ட்டிஸ் இருந்தப்போ அவன் மாத்திரம்தான் கோர்ட்டுக்கு போனோம், தேர்ட் பர்சன் போகிறதுக்கு இல்லை. பட் இந்த 5 எக்ஸப்ஷன்ஸில் థర్డ్ పర్సన్ కూడా కోర్టుకు పోయి అవన్ మేల కేసు ఫైల్ பண்ணலாம். నార్మల్గా ఏమవుతుంది అంటే ఇద్దరు మధ్యలో కాంట్రాక్ట్ ఉన్నప్పుడు వాళ్ళు మాత్రమే కోర్టుకి వెళ్ళాలి, మూడో వ్యక్తి కోర్టుకి వెళ్ళకూడదు. కానీ ఈ సిచ్యువేషన్స్లో దీని ఎక్సెప్షన్స్ అంటారు. ఎక్సెప్షన్స్ ఈ సిచ్యువేషన్స్లో ఏమవుతుంది అంటే థర్డ్ పర్సన్ కూడా వాళ్ళ మీద కేసు ఫైల్ చేసి ఎన్ఫోర్స్ చేయొచ్చు. లెట్ us see what are those 5 points, 5 exceptions in fact that has been recognized. One is beneficiary of a trust, second one is marriage settlement, third one acknowledgement or estoppel or part payment, fourth assignment of a contract, fifth contract through an agent. Let us see. In fact, yesterday we have seen this, again we are going to see. First one is beneficiary of a trust. What is the basic rule? Only the persons who are parties to the contract can sue. Right. Here what happens is, assume that A is there. He is having a property. Now he want to give this property for the benefit of all some third persons. So what happens? He will create a trust in favor of all these persons. Then he will appoint B as a trustee to look after the property of the A for the benefit of all these persons. These persons are known as beneficiaries. So A is there, A is having the property, he is creating a trust, and who is the trustee? B is the trustee, A is the author, B is the trustee. All other persons are known as beneficiaries. Remember, A is having the property, he wants to give his property for the benefit of all the public. So here public are called as, so first point is beneficiary of a trust. So here let us take one example. Trust means, for example, A is there, A is having large property. So he want to use this property for the benefit of the public. So what he will do? A will create one trust for the benefit of this public. So A is known as author of the trust. Now he will create a trust. Now property is under trust. Then he will appoint B to look after the trust property and do good things to the public. So now the contract is between A and B. A is known as author of the trust, B is known as trustee, and these general public are known as beneficiaries. So now the real contract is between A and B, author and the trustee. However, if the trustee misuses the property, beneficiaries, that is general public, can file against the case against B for the enforcement of the trust deed, even though he is a stranger to the contract. புரிஞ்சுதா? So a trust is created for the benefit of the beneficiary in a contract of trust. Trust owner, settler, and the trustee are parties to the contract, and beneficiary is a stranger to the contract. So a beneficiary can enforce the provisions of the trust even though he is a stranger to the contract. Next point is marriage settlement. A stranger to a contract can sue in respect of a marriage settlement. Let us take an example and analyze this case. One boy was there, right? One boy entered into a contract with a girl's father to marry that girl. One boy entered into a contract with girl's father to marry that girl. That means contract is between whom? Boy and the father. But later the boy did not marry the girl. So boy refused to marry the girl. Now the girl is a stranger to the contract between the boy and her father. Now this girl filed a suit against the boy. You understand? So even though there is a contract between the boy and the father, the girl is a stranger to the contract, but she has filed a suit for breach of the contract, and the suit was held to be maintainable even though the girl is a stranger to the contract. So in marriage settlement also, a stranger to a contract can sue in respect of marriage settlement. Third one is acknowledgement or estoppel or part payment. In fact, it is not there due to typing mistake. So third point is acknowledgement or estoppel or part payment. Due to oversight, it has been left over. So kindly note it down. Acknowledgement or estoppel or part payment. So if the promisor by his conduct or acknowledgement or part payment or by estoppel creates a privity of contract between himself and the stranger can sue. If the promisor by his conduct or by acknowledging the part payment or by estoppel creates a privity of contract between himself and the stranger, stranger can sue. The term acknowledge means what? Acceptance of a receipt or admitting a liability. Estoppel means stop denying the truth. Part payment means payment of an amount which does not discharge the liability in full. So in these cases also a stranger to a contract can sue. Fourth one is assignment of a contract. So if the benefits under the contract are assigned to third party, assignee can sue. Assignment means transfer. For example, two parties are there. A is there, B is there, and both enters into a contract. B has to give some money to A, and B has given promissory note to A. It's a contract between A and B. But subsequently A has to give money to C. B has to give money to A has to give money to C. Then A tells to C, Mr. C, B has to give me the money to A. He has given me the promissory note. I will endorse this promissory note in favor of you. You take the money from B. The real contract is between A and B, but A is assigning his contract to C, and the contract, now new contract emerges between C and B. So an existing contract can be replaced with a new contract by changing either of the parties' terms and conditions remaining the same. It is also known as novation of the contract. Now the real contract is between whom? A and B. But A is transferring his promissory note to whom? C. Now C can sue B. So even though she is a stranger, he can file a suit against B for the enforcement of the promissory note. So assignment of a contract. Fifth point is contract through an agent. So we are having one law. It is known as law of agency. So in a law, for example, A is there. A is doing business in Delhi. He wants to expand his business to Mumbai and Calcutta. He will appoint B and C as his agents. So now A is known as principal, B and C are known as agents. Now these agents, they will do the business on behalf of whom? A. During the course of the business, these agents will come into contact with many customers. That means there is a contract between whom? Agents and the customers. But if the agent fails to fulfill their obligation, customers can sue the agents as well as principal A also. The real contract is between whom? Agent and the customers, but customers can file a suit against A, that is the principal, for the enforcement of their rights. So when a person appoints another to act on his behalf with a third party, it is called agency. The person who appoints is called principal, and the person who has been appointed is called agent. When the agent enters into a contract on behalf of the principal can enforce the contract. Even customers also can enforce the contract. Here principal and the customers is stranger to the contract, and agent and other parties are also, they will bound by this agreement. So it is by way of contract through an agent. You can see it in detail in contracts to when law of agency chapter comes. So in the, what is called, in a nutshell, the normal rule is stranger to a contract cannot sue, remember, but in certain circumstances they can sue. These are known as exceptions. Under these five exceptions, a stranger to a contract can sue. One is beneficiary of a trust, second one is marriage settlement, third one is acknowledgement or estoppel or part payment, fourth one is assignment of a contract, fifth one is contract through an agent. So understand, children? So tomorrow we are going to see another lecture, capacity to contract. Have a good day. This is Srikanth signing off.